And welcome back. Well, it's just a week since David Bain was officially found to be not guilty of the murders of his parents and siblings. As the verdict was announced by the jury foreman, his supporters inside the court were ecstatic, and we saw David Bain walk out of that courtroom door as a free man. But that's by no means the end of the story. There's speculation as to how he must be feeling after being wrongly incarcerated for 13 years. Just what effect does that have on a person? And questions are being asked about how well New Zealand's jury system works. Does it really work, or should we change it for something perhaps more modern? Well, in the studio with me to talk about these issues is Professor Warren Brookbanks. He's the criminal law specialist at the University of Auckland. Warren, thanks very much indeed for joining us on the programme.
Thank you.
It has been an astonishing case, hasn't it?
It has been an astonishing case, both in terms of the facts involved in the case itself. Very unusual to have a major homicide of this nature, but also the length and the duration of the legal proceedings which have followed in the train of the events. I
mean, there are so many questions I have to ask you, and I think we just have to push the next two programmes out of the way to get them all in. But let's start with the compensation issue. Yeah. They're saying that David Bain may not be compensated because he's been proven not guilty, he's not been proven innocent. But surely after this length of time, you can't prove something else.
Well, he's certainly entitled to apply for compensation. The rules around it are not that straightforward. It's a matter of the government's discretion. He will have to make an application to the government, and I think it's under the cabinet rules. The government then will appoint a senior lawyer, a QC, who will investigate the case and then produce a report in which he recommends for or against compensation being awarded. The problem, of course, from David Bain's point of view, is that in these proceedings, because he's the claimant, he has to prove his innocence on a balance of probabilities. And that may be a difficult task in the circumstances.
Well, let's talk a bit about the process of the way things change. So he went to the appeal court and then on to the Privy Council. Now, it's almost the end of an era as far as the Privy Council is concerned, isn't it?
Well, yes. I mean, appeals to the Privy Council from this point on, of course, or since the enactment of the legislation setting up the Supreme Court, have now been abolished. So there may be still some cases where the issues occurred before the establishment of the Supreme Court, where the Privy Council is still the final appellate court, but I suspect they're likely to be very few.
So this is, I guess, the end of the line for that.
Yeah, I think so.
I guess the question then is a Supreme Court going to have the same judicial grunt as the Privy Council?
Well, my own view is that it will. We have superbly qualified and experienced judges in our highest courts, certainly in the current Supreme Court and in the Court of Appeal. And although we are a small country, New Zealand has a fine reputation for having a very sound and able judiciary, and I think that's certainly evident in the currently constituted Supreme Court.
I guess what worries people, though, is that they see the forensic experts coming from the UK who overturn what our own homegrown forensic experts are saying. But then we see that it took so long for Joe Karam to fight to get that case to the Privy Council. And it does feel to an outsider like they were saying, well, look, don't bother us now. You know, we know what's best and we don't want any outsiders coming to look at it. You can understand why people are uncomfortable.
Well, you know, in any trial, it's open to the parties to adduce any evidence which may support their case. And so, you know, in a case like this, if there is a forensic expert in the UK or the US or some other country who is uniquely equipped to evaluate particular forensic evidence, then there's no objection to such experts being brought into a trial, and that happens quite frequently.
But is the fact that it's going to be it will be an internal judge who's making decisions on the case, does that mean that there will be a reluctance to bring in outsiders because it makes us feel like we're not grown-ups anymore and we need to get help from outside?
Well, that has been a perception in the past, and certainly when the Privy Council was operating, there were very few criminal cases that ever made it to the Privy Council, a very small handful, because it was a very costly procedure. and at that stage there was a perception that having access to the best legal minds in the Commonwealth may have been of particular benefit to a defendant. But we've moved past that, and while you may want to argue whether our best judges are as good as the best judges in the UK, I think the experience of the court speaks for itself, and certainly since the Supreme Court was established, it has had to consider many appeal applications, and it is, people have now, I think, made the mental adjustment to the fact that that is our final appellate court, whatever their views might have been about the values of the Privy Council.
Because in the end it was a punishing case for the jury. It was more than 50 days of
it was a very difficult case and a massive amount of evidence to evaluate. I think a very difficult task for the jury.
Is the jury the best way? I mean, with that amount of evidence, would an expert judge be a better way to go forward, or some other system?
Well, there is provision in legislation for judges to sit alone in cases of particular complexity, but they tend to be commercial cases or cases where there is very difficult and complex technical evidence, where arguably a jury would not have the ability to evaluate it. But in the vast majority of cases where the genius of the jury system is that 12 tried and true members of the community will make determinations of fact about a person's guilt, which has been in place for hundreds of years, does in some curious way work. And although juries, we don't know a lot about how juries deliberate, because you can't be a fly on the wall, you can only hear anecdotally, but I think in most cases they get it right. And the other thing to remember here is that the number of cases that go to a jury are relatively few in overall terms. It's a very small percentage of the total number of prosecutions in any one year. And the numbers that are successful, of course, are even smaller.
Would you say, summing up, that the judicial system has been damaged by the Bain case or strengthened?
I would say the judicial system's been strengthened. The fact that it's been an inordinately complex case with multiple appeals is simply evidence of the complex and highly unusual fact situation that generated the trials. But I think the system has worked. I mean, we had an initial acquittal. There were 3 appeals to the Court of Appeal. There was a Governor-General's petition to exercise the royal prerogative, Privy Council appeal. The system has worked at every stage, and although people will argue about the correctness of the results of each of those proceedings, I think it shows that the system does work, even albeit in a complex way.
Well, it's been a remarkable story. Warren, thank you very much indeed.
You're very welcome.
Thank you. Well, after the break, Scott Kelso investigates the concept of sanctuary and your right to say goodbye to a loved one without secular interference. More on that story in a moment.